Swain Township versus Douglas Stroud, case number 24T00169.
Paul Barnett on behalf of the township.
Allison Muller, Assistant Public Defender, here on behalf of Douglas Stroud. Mr. Stroud, can you state your name?
It's Douglas Stroud.
Thank you, Mr. Stroud. Please turn on your camera. So, Mr. Stroud is here for a pretrial and also bond violation. It appears that Mr. Stroud tested positive for cocaine on August 2nd, 2024, and he has missed every test since then. August 7th, August 16th, September 23rd, September 30th, October 4th, 2024, and is just failing to test because I guess he decided he didn't want to do that. You have a right to have a hearing on whether you're in violation of your bond, sir. If I find that you're in violation of your bond can be revoked. Do you understand?
Yes.
All right. Ms. Muller, what would you and your client like to do?
I'm sorry, Your Honor. I did not see the report. I'm sorry.
All right, we'll send it back to you.
Thank you, Your Honor. If I could talk with Mr. Stroud in a breakout room, I would appreciate that.
All right, we'll give me one moment to get this report. In addition to that, just so wait, there's more. Wait 1 second. He's also on SoberLink, and he does not test between 6 and 9 a.m. as scheduled. He tests basically when he gets ready to. On August 16th, he didn't test between that time, and each time will be the same. He tested at 1:16 p.m. On August 20th, 9:50 a.m. On August 21st, 9:28 a.m. On August 26th, 10:02 a.m. On August 8th at 10:21. September 1st at 10:09. September 13th at 9:10. September 16th at 10:03. September 22nd at 11:04. September 27th at 11:39. Then on October 6th, he decided he wouldn't test until 3:49 p.m. We'll send this over to you.
Thank you.
Maybe April will come in. So we can send it.
A few moments later.
All right, what would your client like to do?
Your Honor, Mr. Stroud will admit to the violations, and I would just like a chance to advocate for him when appropriate.
Okay. Mr. Stroud, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. All right, Mr. Stroud, I listed a number of violations that you had committed during the arraignment. Do you admit that you committed those violations, sir?
I'm sorry.
I listed a number of violations that you committed during the time that I just arraigned you before you went into the breakout room. Do you admit that you violated those terms of your bond?
Yes.
You're waiving your right to have a hearing, and you're going to admit to the bond violations?
Yeah. As far as the drug test goes, I didn't have a supervisor assigned.
Sir,
When they,
I'm not, sir.
I'm sorry.
I'm not asking for an explanation from you. I'm only asking if you're admitting or not admitting. Do you want a hearing? Or not?
Well, no. No, yeah, I'm not admitting because no.
Mr. Stroud, I think as we discussed, it's better to provide the explanation. It was court ordered to do the testing. We can let the judge know what your misunderstanding was, but I don't think having a hearing, we would have to show that the testing was not ordered and that you didn't violate. I don't think we'll be able to accomplish that. So I think it's in your best interest to admit and not request a hearing on this, but that's ultimately up to you, okay?
Oh, okay. I'm sorry. I misunderstood. I have a hard time. But yeah, then yes.
So you're waiving your right to have a hearing, and you're going to admit to the violations?
Yes.
All right. And so you are acknowledging that you violated in all the ways that I indicated, the positive cocaine, the not testing, and the late tests, correct?
Yes.
Right. I find that there's a knowing and willing admission to the violations. Are you satisfied, Mr. Barnett?
Yes, Your Honor. Thank you.
Defense is satisfied as well, Your Honor. Thank you.
All right. What would you like to say on behalf of your client?
Your Honor, I think the testing, and to be honest, I was very confused. I did not know he was ordered to be testing. And I was looking back through the last report I got from Mr. Stroud was on September, I believe, 13th. No, sorry, it was dated September 14th. And on there's no drug results listed. There's nothing mentioning the results. There's only the belated sober links, which I know we discussed at his last court date on the 18th. Mr. Stroud, I think, was, and correct me if I'm wrong, Mr. Barnett, I know it's not, of course, okay that he tested positive for cocaine. The offense only involves alcohol, I believe. He explained to the magistrate when he was arraigned that he is a truck driver. He's hardly ever in Washtenaw County. He's very infrequently in Detroit when he comes back with his truck. So he explained that situation. I think he was ordered to do one initial test. That, of course, as I see now for the first time, was positive. So I told him, well, if it was positive, then of course you're going to have to continue testing for substances. But he was told at corrections to reach out to his supervisor. He didn't have a supervisor at the time. He does now. It's Mr. Keith Wells. So I don't know what got lost in translation, but he never did test. I didn't know until today that he was supposed to be testing or had missed all these tests, or I would have advised him at his last date back on the 18th to come into compliance immediately. So it doesn't excuse it. You know, he understands that was on him to find out for sure from community corrections what steps were needed, especially after that positive test. As far as the late sober links, I know the court strongly advised him to come into compliance with testing within the window on the 18th. It does look like he has still had some late blows. He's done better since the 18th. It looks like he's had 3
Really?
since he was last in court.
3:49 p.m. is better.
Well, no, Your Honor, no, I just meant less. He's having less frequent. He had like 1, 2, 3, 4. He had 7 or 8 before that date. So I only meant it in that sense of it's happening less frequently, but it's still not okay. I told him there's no excuse. He has to test within those windows. Absolutely.
Mr. Barnett?
I mean, clearly he doesn't understand that he needs to be in compliance with this, or the alternative is that he can be held in jail pending the disposition of this case. I mean, I find it kind of troubling that he's a truck driver and he's got a drunk driving case with a .229 and he's testing whenever he kind of feels like it. And he had a positive.
And testing positive for cocaine.
Yeah, and I just was going to say that. And also testing positive for cocaine. I mean, that's just a recipe for disaster. So,
Right. I mean, someone who's driving, are these semis? He's behind the wheel of semis, drinking and high. I don't understand this argument. I mean, I am deeply disturbed. Going from Detroit to Tennessee every other day. And we can't prove whether he is drinking or not drinking because he's testing when he gets ready to. I can understand how he may have been confused. And the fact that the report, the first one didn't reflect this cocaine positive, means that we didn't have that part of the conversation with him last time. But I clearly had a conversation with him about no more late testing, but yet I'm still having late testing. And not only that, he didn't test until 3:49 p.m., which is enough time to get anything you want to get out of your system.
Truck breaks down and
He can speak if you want him to.
I'm sorry.
That's up to you.
I with my
Well,
semi, I have a
Go ahead,
dog
Mr. Stroud.
and
You should listen to your attorney.
okay. My silver link was
Mr.
just
Stroud,
left on my
I
truck.
understand that. I understand you have, but I don't think there's an excuse we can provide to excuse the late testing. Your Honor, advise, and I understand the court and the prosecutor's concerns very well, especially since, like you said, given his profession. I don't know if the court would consider a scram tether at this time. That I did let him know he'd need to complete those downloads timely.
Yeah. We don't know until he gets downloaded. I know about it. I mean, I'm just seriously considering just revoking his bond because I just don't trust him behind the wheel of a semi. This is what I'm going to do. Defendant is to test within 24 hours. How many do we have on October 29th? Or Monday, either of those days. One moment, please. And the 29th. So 28th it is. All right, we're gonna put him on for Monday, October 28th, 2024 at 10 a.m. Sir, you need to test. I don't care where you do it at, how you do it, but you better test within 24 hours. If you fail to test within 24 hours, I'm just gonna immediately issue a bench warrant. If you test positive, then at that point in time, I'm gonna give you a bond with a cash component to it. Do you understand me?
Yes.
All right. I'll see you here on October 28th at 10 a.m.
Thank you, Your Honor. And just one thing, Your Honor, I'm sorry. Mr. Burnett, I'll send you an email. We're just waiting for the body worn camera on this, and then hopefully we can move towards a speedy resolution.
Yep, very good. You send me an email on that. I thought I'd already sent that, but
Okay, I'll check again. Thank you.
Thank you. Ypsilanti Township versus Michelle Servos, case number 23W002435.
He was special.